Welcome to LawPath's legal education videos. My name is Damin Murdock. I've been a lawyer for more than 10 years. Today we're talking about why companies should have website terms and conditions. Now, website terms and conditions are obviously found on websites. I'm sure you've been bound by them many a times. But what is the importance of them and what do they actually say? Now, there's two different kinds of website terms and conditions. One's called a browse wrap, and one's called a click wrap. Both of them originated in America, and originally you could go to a website, read the website, leave the website, and be bound by the terms of that website that you just visited, even though you didn't know there were any terms, even though you didn't read those terms. That's called a browse wrap agreement. Now, a browse wrap agreement is generally in Australia not legally binding, unless you can establish that the user of the website was notified of the existence of those terms and you can demonstrate that they've potentially read those terms as well. That's why back in the early 2000s, if you ever downloaded Microsoft or anything like that, there was a requirement for you to actually scroll. And you actually had to drag the scroll bar down, and that was just to show that you've actively been on the website and actively seen the terms. But at the end of the day, with technology now, there's really no need for you to have a browse wrap agreement, and you really should have terms and conditions, which are what's called a click wrap agreement. And a click wrap agreement is where you click to accept. So when you look at these website terms and conditions, they'll normally say, by you visiting our website, by you buying anything from our website, by you clicking to accept, you accept these terms. And that's to try to get around the browse wrap requirement, but also try to make it as legally as enforceable as much as possible. And website terms and conditions is just like any contract. There's an offer to sell or offer of services. There's a meeting of the minds of what they say, and there's an acceptance. And you accept by browsing the website potentially, but more likely than not, clicking to accept, buying the goods, buying the services, or whatever you're using that website for. Now, the reason why you want website terms and conditions is, one, to make sure that you have a contract with your consumer. You want to make sure that they know what they're getting into, and you want to be able to bind them to certain provisions. That comes down to just like any other contract. They're liable for the purchase of the goods. There's certain warranties, there's certain disclaimers, there's certain limited liability in the event that your goods or services are defective or whatever it might be. There's a dispute resolution clause where they can't necessarily just take you to court, but they have to mediate it. There's applicable law, and there's a venue for the applicable law. So if there is a dispute, where is that dispute going to be held? What law is going to be applicable? Now, what's important is if you're doing business outside of Australia, then it's really imperative that you do have website terms and conditions, and you should consider getting an arbitration clause. An arbitration clause is normally drafted around the New York Convention on the Foreign Recognition and Enforcement of Arbitration Awards 1958. That is a United Nations convention, short form down to the New York Convention. 152 countries have signed that convention, and it basically says when you enter into a commercial arrangement, two commercial parties can negotiate and agree on what law is applicable and where and how a dispute will be resolved. And if you have an arbitration clause which is properly drafted, then that means that the other side cannot haul you into courts internationally for breach of the contract. But instead, if they want to dispute you, they have to dispute you under the applicable law, under your terms, and in the location of your terms by way of an arbitrator. And once that arbitrator makes a decision, that decision can now be enforced in all 151 countries around the world. And if the other side tries to go to a court in one of the countries around in the 152 countries around the world, the judge is by law under the International Convention prohibited from hearing that case because you had a binding arbitration clause. So it means, one, you can hold them here and get a judgment here. Two, you can enforce your judgment over there, wherever they're based. And three, you're not going to get hauled into court over there. Now, the benefit of that is that if you don't have an arbitration clause, then you're stuck getting a judgment in Australia, and the foreign buyer might not have any assets here. So you can't actually enforce it. And America and Canada and Australia, they don't have mutual recognition of their judgments. So if you get someone from New York that buys something off your website or a service off your website, and you get judgment against them here, they have no assets here. You take your judgment and try to get it enforced in New York, you won't be able to because they don't necessarily recognize an Australian judgment in New York. So the reason why you want to have a website is you want to spell out what services are being offered, spell out what warranties you might have, spell out what limited liability or disclaimers you might have, spell out how you're going to resolve the dispute and what applicable law is going to apply, and make sure you get that offer and acceptance in writing by them clicking to accept so that they're bound by it. So it's really important to have website terms and conditions. These are some of the elements that are normally in it. LawPath has a bunch of templates, but a lot of times you also might be looking for tailored work as well. So if you're looking for something tailored, you got to consider your business and decide whether a legal template is going to be suitable or whether you need something special for your website because your website's a little bit different than the standard one. And that's what's important about defining the services, defining the warranties, defining the refund policy, choosing the applicable law, making sure you have an arbitration clause if you're dealing internationally. So thank you very much for watching this video. If you enjoyed this video, please make sure you subscribe to our YouTube channel and give us a thumbs up. If you have any questions, visit www.lawpath.com.au. Thank you very much, and I'll see you next time.